All right, everyone, want to officially welcome you to the next Founders Live Conversations. I am Nick Hughes. I'm the founder and CEO of Founders Live. And today we have a very special guest with us that has come back a few times now to really join us and introduce what they offer and what he offers as awesome opportunity for early stage startups to really have general counsel and legal counsel, but also we're just opening a room to have a little discussion around even general startup legal questions. I want to introduce Alberto Mujica from ScaleUp Legal. Alberto, thanks for joining us and welcome to the conversation.
Hello, Nick. It's great to see you and great to see everyone else as well. Good to see you, Lewis. And here I am. I'm always happy to join Founders Live and to help all of you founders navigate through the legal stuff. It's extremely important. You got to remember that for your startup, what you have is, you through legal means, you're able to create that moat that you're trying to create to prevent competitors. It's through legal means is it that you're able to structure a deal that a VC will be interested in participating in. So all of these things are pretty important, and they're complicated, and there's lots of particular terminology, and the differences are relevant. They're important. They can make a difference. They can mean a lot to your business. It may mean being able to fend off competitors. It may mean paying a whole lot more or less taxes. It's all of these things that are pretty relevant. About me, really quick. I'm an attorney. Before being an attorney, I was a systems engineer and a data scientist. I went to law school in the University of Barcelona, at Nova, and at Berkeley. I've specialized in all aspects of venture capital, corporate law, contracts, and VC and intellectual property. So, I'm more than happy to connect. I'm gonna throw in my LinkedIn as well if you guys want to connect. And what we've done at ScaleUp Legal, after I've been in-house counsel, and I've also worked at several firms. And after my last success working with a startup, CoachUp, we were able to raise about $300 million with them. I came out and said, I want to help other startups do the same. So I founded ScaleUp Legal. And what we do is we provide you essentially in-house counsel services at a 70% discount in exchange for equity. So we become your investor too. Now, with that, I guess I'll open it up for questions, and if there's no particular questions yet, I'll start talking about the differences between entities, maybe talking a little bit about trademarks and patents and their differences. But I see that we actually already have questions, so
Yeah, well,
maybe
this is great. And Alberto, again, I want to officially kind of welcome you to the conversation, and we already have questions flying in. So we might even just kind of jump into this. And everyone, just kind of the name of the game here is you all guide this in some ways. If you have questions that we can put into the room, we will just start, rocking and rolling with Alberto here. And if not, hey, we have talking points that we can review as well. But feel free to, you see there that there's, questions are starting to get dropped in here. So let's just kind of kick it off. We have Robert has asked around, copyright and computer code. And, it says copyright is automatic, uncertain if the office will accept my code. I'm not 100% sure where that specific, I don't know, Alberto, if you can grasp that, but maybe just talk more about when someone is considering their code, how does that line up with, can you copyright it? And especially if, we can even slide this conversation into, where AI is going with all of this. But I don't know. Can you take that question? Do you feel like you can answer that?
Absolutely, absolutely. That's a great question, Robert. And it seems like you've done some homework because at least you know that copyright is automatic. And it is. It's automatic. As soon as you create something, a work, let's say you write some code, even you doodle something into a napkin, well, you automatically have copyrighted to that. Once you create something and you fix it onto a medium, it is yours. You don't need to register it. You already have copyright over that. But there are benefits to registration, including statutory damages in case someone infringes, a presumption of ownership in the copyright, which are benefits in the event that there's an infringement. But yes, you automatically have a copyright, and you have the right to defend that copyright even if you haven't registered it. It just becomes more difficult to defend uh, um, in the event of an infringement if you haven't registered it. Now, when it comes to computer code, like I said, Robert, apparently you've done some homework, which is great, because computer code, often people wonder, well, do you patent computer code? There are some things that you can patent, but for the most part, computer code is copyrightable. And yes, I presume that if your software code, your code is original, the Copyright Office is very much likely to accept it. They don't go out, and it's not like a patent where they have to do an examination, whether your code is good or serves any purpose or doesn't infringe on anyone else. All you have to do is register it, and the Copyright Office will accept your code. And if you have a valuable piece of software, I think it's important that you register it with the Copyright Office so that, if someone infringes, you're able to get statutory damages, you get the presumption of ownership of the copyright, and it's also serves as notice that the code is yours. So to answer to directly answer your question, yes, the Copyright Office will accept your code, because, like I said, they're not going to go. They don't registering a copyright is not the same process as a patent where they have to check and see if it's acceptable or not. No, if you say it's yours unless someone goes in and challenges that to the Copyright Office.
And
So
yeah, and Alberto, just to tie in another one of these questions, just kind of taking it towards the generative AI. Gabriel mentions with regard to generative AI, are the outputs then copywritten, or is it just the prompts or the inputs? And that just leads to just speak a little bit. And again, we've got a number of questions now, so we really want to hit all of them. But maybe just one quick thought on how is it interpreted with the generative AI stuff now, which in some ways there is sometimes a human influencing that and sometimes not.
well, I'm glad you pulled me back into the AI because I didn't touch on it. But here's the thing. AI is so new, and our judicial system is so slow, rightfully in a way. But our judicial system is so slow that, well, both our legislative system and our judicial system are very slow. We still don't have any laws that are in particular addressing AI. Um, and the common law, the law that comes from precedent and jurisprudence and judge determined law, these issues are still running through the courts, and well, Congress, as we know, isn't very efficient at anything. So, um, but the fact is, when it comes to AI, a lot of this hasn't been determined. But what has been determined is a following, which is pretty important. Output from AI is not copyrightable because it is not your work. The intent and one of the few constitutional clauses that states clearly its purpose is the clause on intellectual property. And in the Constitution, it states that the purpose of protecting intellectual property is to incentivize the creation of new inventions and incentivize new works, right? So copyright only protects works made by people. So an AI that spits out something, that output is not copyrightable because it doesn't serve the purpose of the intellectual property protection in the Constitution, because it's not incentivizing anyone to come up with anything new. AI can't be incentivized by the protection of that output. Now, whether or not the input, the prompts, are copyrightable is still undecided. So I can't say whether or not it's protected. It's still in the process of being decided. But if I had to guess, and based on a lot of the conversations between the judges and the decisions, I think it's likely that it will ultimately be protectable, just like any other creative work, right? So if you doodle something on a napkin, it's copyrighted automatically, as I said before. So a prompt that you put into AI that produces a very specific output, and if the prompt, the more complex it becomes, it's more likely to be protectable with copyright. But like many other things, if you take a picture of a sunset, its level of copyright protection is minimal because we all have access to sunsets. Every day there's a sunset, and that's not a great level of protection. In the same way, a prompt, unless it's very elaborate, very specific, it's going to have very little copyright protection, and even that's questionable right now.
Awesome. Well, this is good. This is good. Hope everyone that at least gave you some thought and perspective. And clearly, it's something that's much more than just a 5-minute answer. So feel free to we dropped Alberto's link in there, and if you have other specific links for like a calendar or whatever, we can make sure you get that. But so for follow-up questions. But this is great, everyone. We're gonna jump back up to a previous question. I want to shift into more, creation of businesses and even, these sort of legal entities, what it takes to do it. All right. And so we have one, Michaela, I'm hoping I say that correctly. And she says, we are starting a business in the US. They already have a business in Sweden. I'm assuming Stockholm, but maybe not. But awesome to see you here today. How much should they calculate in legal fees for documents to get them up and running? So this is maybe a question around like, if a team is looking to really get started and maybe engage with a firm like yours, what are the expected base, fee structure that, or at least budget to get started, especially with a new entity and incorporation?
It can vary greatly, right? If it's a simple structure, it can run a couple $1,000. If it's more, it can go a lot more, right? There's never an upper limit. But you can probably it'll run you a couple $1,000s, maybe $3,000, depending on the complexity. But when it comes to creating an entity, two very important factors are involved. I mean, how complex is what you want to do, and are you looking for investors? Why? Because, typically investors only want to invest in Delaware companies. So that changes things, right? Here, as opposed to other jurisdictions, and if you're in Sweden, I mean, I went to the University of Barcelona, so I'm actually aware of EU law and how corporate law is in Europe, and it's very different there. It's far more complex and more difficult to do. I'm not familiar with Sweden in particular, but in Europe in general, it's a little more complex. It's more bureaucratic. Here, it's a lot simpler. It's quicker. Um, but uh, but the fact is, it is state by state. So if incorporating in Delaware versus incorporating in Texas makes an actual difference. And when it comes to, if you're looking for investors, there's no question. It's got to be Delaware. Um, but it also includes some, complexities where if you're looking for something that's easy to manage, it's only going to be a few partners, and you're not looking for investors, then maybe an LLC is a better choice because it's a lot simpler, and it's easy to manage, and it's easy to change, and it's easy to unwind. Um, so there's a lot of factors to consider. Whether you want to bylaws, the bylaws are always more complex. You need to have a board of directors, all of these things, and these are corporations versus LLCs, which are limited liability companies, are far easier to manage with your operating agreement. You're super flexible in terms of how you want to manage your company. So I would say give us a call. We'll try to figure this whole thing out for you and recommend what's best for you. So
Awesome. Well, Michaela, I hope that that at least gave you some thought, and I would say best to probably chat a little deeper with Alberto there, and that's great. Congratulations on expansion and looking to land some great things here in the U.S. So thank you. All right, we actually have in some ways a similar, maybe just going into, you just mentioned, you described a little bit of like LLC versus C Corp, S Corp. Godson mentions maybe the question here around, is it better to wait until you have an investor committed to like really get that entity going, especially like, some are suggested, hey, just if you need to get some structure, get an LC, it's fairly quickly, you can easily do that, it's fairly affordable, but then wait until you actually have capital committed, and especially in an investor group, if not at least the first investor, to get that maybe C Corp created. Do you have any thoughts around that? And you did mention Delaware. Delaware, you can touch a little bit more on that, but it's just very favorable to startups and investors, and just all of, with the state there. So maybe speak a little bit more on even the timing of how you incorporate, and is it a good idea just to get an LLC just to get the some sort of legal framework there, and then you can shift and adjust a year or two later when you do have those investors?
so I would say never operate a business without an entity. So don't wait for investors. Don't wait. If you're receiving any money from anybody, if you're signing any contract, if you're doing anything from your business, make sure you have an entity, whether it's an LLC, whether it's in Texas, in Florida, in Nevada, anywhere. You should have an entity. Why? the whole purpose of having an entity is to limit your liability, right? And so long as you're operating as either a sole proprietorship or a partnership, you have unlimited liability. So anything that happens in relation to the business, all of your assets, your home, your car, your kids' college fund, all of these things are up for grabs. So never operate without an entity. Should you start with something simple? Depends on how quickly you expect to raise capital. If it's going to take you a year or two, start right away with the proper structure. Get started with a Delaware entity. Make sure you have you use that entity to structure your offering to investors, because investors need to feel comfortable investing in you. And you need to have a solid offering that, that shows that you're serious about your business. It's also about, to them, it's extremely important to make sure that when that's why the investors will do a whole lot of due diligence, um, and make sure that you're legitimate. And if you don't have the proper corporate structure, you're not even going to get past that unless you have some outrageously great business, which you may. But if I were to be your attorney, and I would recommend start off with an entity that's ready to accept investors, that's going to attract investors. And that would be like a Delaware C Corp. And it's going to be a little more complex. The complexity, the thing is, for example, a Delaware C Corp is by default more complex than an LLC, but it's capable of becoming extremely complex. But so long as you're small and your business has not brought in lots of shareholders and investors and so on, it can still be marginally more complex, but you'll be ready to, if you structure it correctly, you'll be ready to take in investors. And you want to be ready to take on investors if you're looking for investment.
Yeah. Grant mentions here, can you expand a little bit? And I think let's put a nail in this for Delaware. And I know that, some people here, this might be a little new to you, but Delaware just has a corporate structure that's just more just basically recognized and familiar to most investors here in the United States and probably globally. It just has become the default. And the way I hear it is, if you go with the one that's most familiar, you're going to get least amount of snags and least amount of confusion, especially when you're trying to move fast. So, Alberto, just maybe a quick one on why Delaware, and then
Sure, absolutely. The bottom line is Delaware. The good thing is Delaware's code, its statutes have pretty much, most states have copied Delaware statutes for the most part, with their own differences. But Delaware's statutes, corporate statutes, are very mature. They have a dedicated court to corporate matters, and they have expert judges. So the jurisprudence that is produced in Delaware is super influential and super important across the nation. In fact, so I went to UC Berkeley, and I also went to Nova, which is in Florida. So UC Berkeley's in California, Nova's in Florida. You would expect that they would teach you Florida and California law. They don't. When it comes to corporations. When it comes to corporations, they don't teach you Florida and California law. They teach you Delaware law because they have Delaware simply has the important jurisprudence, the expert judges, and as a result, one of the big things that investors seek is reliability. You know, being able to rely on the outcome of a dispute, for example, or a lawsuit. And when you have very, established, tried and true jurisprudence, they can rely on it. And so they will prefer Delaware simply because they know what the outcome of a dispute is going to be. It's just what they trust. Is it justified? It doesn't matter. The fact is, an investor feels more comfortable investing in a Delaware corporation, and that should be enough for an entrepreneur that's seeking capital from investors. That's enough to bring you into, to say that you should create a Delaware corporation.
All right, good stuff there. We're going to shift to Michael has a question, and then we're now going to kind of, slip a little angle in a little different way around, even, how to form a company in terms of even equity and splits and co-founders. And so Michael has a question around, if he already has granted a patent to his name, let's say, and he's bringing that into the maybe like a previous art or IP that is forming this entity. He's bringing that to the table, and looking to take on a new co-founder. We'll call them a technical co-founder. How should they look at splitting the equity? And this is always a challenging one, everyone, as you form, you've determined, all right, we're going to form that C Corp in Delaware, but the conversation around who owns what, how much. I have my thoughts on this, but should the IP and be in a different entity, and then the operating company is split more evenly, or what would you suggest they look at when someone is bringing even like granted patents or some very valuable aspect to the table on day one? What is the way to look at equity splits?
Well, if you have a patent, that is extremely valuable. Patents are very difficult to get and very expensive to get. Patents, and patents give you the strongest level of protection. You essentially have a monopoly on that for 20 years. So it's extremely valuable as a moat around your business to fend off competitors while you get ahead. So it's extremely valuable. And if one of the founders has a patent and the patent is important for the business, number one, the most important thing is to assign ownership of that patent to the entity, because that's the only way that you can then split ownership on that, right? Otherwise, if the inventor can still be the same person, but ownership of a patent is different. So the number one thing is assigning the patent to the entity. Then when it comes to, if you're the founder and the owner of the patent, and you assign the patent to the entity, and you're going to bring someone else in, there are a million ways to do it. But one important way to do it is to say, okay, well, here's a grant of stock that vests over a period of time. because you don't want to give everything away day one, and 50% of your patent or your company is gone. You want that to vest over time so that you get the productivity from that co-founder or that partner or that investor. Obviously, well, an investor is a little different because an investor is putting in money, and that's very important in order for you to exploit, grow your business, exploit your patent, etc. But one way I would do it is like that. First, assign the patent to the corporation, and then issue shares at vest over a period of time. Typically, it's 4 years, 5 years or so.
There you go. Very, very, very good. When I said I have thoughts, that was really that direction around, just having granting that stock that vests, and understanding that, when you just simplistically, and I'm speaking founder and, like co-founders, as you start from the simple, well, what percentage do I have? I mean, and then these, again, at some point you have to start somewhere. But if it's two of you or three of you, you're saying, hey, we go 50-50 or we go a thirds. There's a whole conversation on if that should be the case. But generally speaking, it's very, very smart to have vesting, meaning they earn it over time, so that it, more often than not, it happens that there's a breakup, or there's life happens and someone's gonna go do something else, or
Right.
whatever happens. And so, maybe that vesting was a 4-year schedule and they only lasted a year and a half. Well, they're only going to get that amount that they earned over that time. And so, these are important. These are, the numbers get pretty significant sometimes. And, you want to make sure that you have a great partnership, there's trust there, but you have these documents in place that illustrate that longer relationship. And with vesting, they're going to get whatever they got and they deserved, but not everything that the number was determined up front. Right.
And I'll add to that. I mean, the best, and this is where having the proper legal counsel really counts, is in that the best way to prevent conflicts and founder conflicts is one of the top reasons why uh, startups fail. One of the best ways to prevent conflicts between founders, early employees and so on, is to have all of these things well documented, following, in a fair way, and defined. Oh no, I don't know how many clients I've had that come to me. Well, we don't have an operating agreement, we don't have a partnership agreement, we don't have, and he wants to get this, he wants to get that, and then and we're stuck, having to unravel a big mess where there's no documents, and you don't want to be in that position. You don't want to put yourself in that position. Um, maybe you completely trust your partner, and that may be the case. Uh, but even in the best of situations, then it's just mess, and unraveling that mess, even among parties that have the best faith in each other, becomes messy and expensive to unravel. So it's really important to look ahead and address these issues ahead of time.
Yeah. So we're going to bounce back up to Gabriel. I mentioned this a while ago, or asked the question of actually just, the essentially, do you have a recommendation around the generating all of the ancillary policies and documents needed to support, your website and your company, from like terms and conditions, privacy policies, cookie policies, data. Is there a direction you could point people that might be a nice plug in or how would you suggest they look at a lot of those supporting policies and documents to make sure that operations are solid?
Uh, that can vary greatly, right? If you're a data-driven business, you know, this is going to be a very complex privacy policy. You're going to have a very, you might, depending on whether you're transferring data across the Atlantic, you're going to need a DPA or a data privacy agreement in order to comply with European law. Um, More and more countries are requiring these kinds of things. You need to comply with the data privacy framework now, as the US is maturing into its privacy laws. Um, so if you're a data-driven business, I can't tell you anything because it's going to be very customized, right? If you're a business that, I don't know, sells widgets or has a very something that's not data driven, then um, you might be able to go out there and get a template from someone, but it really depends on what you are actually doing, and you want to say what you do and do what you say, right? So let's say terms and conditions. It's extremely important to come up with a proper terms and conditions about your product, the way you function, the way your corporation does things. Um, the contract that you have with your customers is extremely important, and that's what it is. The terms and conditions are the contract that you're establishing with your customers, and it's important that it reflect what you do, reflect what you're willing to give, and what you are committing your customer to give or to do, and no two are the same. No two are the same. And each one is extremely important to your business.
Okay.
So
Yeah.
I would say, unless you have a website that only provides information and your business does not take orders online, and you sell, I don't know, things without recording anything other than payment information, I would recommend talk to an attorney to figure out what your terms and conditions, what your privacy policy, and all of these other procedures should be in order for you to remain compliant. Cases where even small businesses have lost millions of dollars over non-compliance with GDPR, with other privacy laws. And you don't want to be in that position.
Yeah, yeah. And on this topic, we're gonna pull in another one of these questions from Johnny here. And thanks, Johnny. It's good to see you there. And actually mentioning from Jordan Freda, founder of Moom, if you run an open digital community, such as an app that people can join and free, for free, and they can chat and interact, basically allow, putting it out there where people can interact, chat, and actually put content down. What is the liability around situations when community members are either expressing their harm or harm to others? Really what has been created is kind of a open town square. How much of those companies that are providing that are liable for their members doing things digitally? And this could be like someone in a different country that is doing something, but on your platform. What should we think about on those sort of things?
Well, but I think you guys have I presume some of you may have seen the congressional hearings just last week with Zuckerberg and TikToks and so on. Things are changing legislatively, but it would be unfair to create legislation that assigns liability to a company for the things that other people do, unless they're actually, encouraging that or are not policing that. So today, there is a safe harbor for companies that do publish user-generated content. And the safe harbor applies in many ways, applies to liability, applies to copyright infringement, all of these things. And the bottom line is, so long as the company is, monitoring their content, removing content when they need to, they're responsive to copyright takedown notices, all of these things, then they are treated, they are in a safe harbor for the things that their users may generate, or the content that their users may generate on their platform. So the idea is, legislatively, the idea is, let's create a way that these companies feel comfortable creating such places of exchange of information and ideas, without assigning too much liability to them. But if I were to guess, in the future, there's going to be more responsibility assigned to the platform to monitor and keep track of and keep the platform safe. Although I can't imagine that any new legislation that comes forward will not have some sort of safe harbor as well, because you can't assign all the liability to the platform when the users are the ones generating the content. So there's a balancing act there. Safe harbor gives you some security, but it only works if you are being responsible and you're meeting certain criteria and you're doing things properly. If you're not, then that safe harbor doesn't apply to you. So that's what happens with user-generated content in general.
Awesome. This is good. This is good. We're gonna go back up to Godson's next question here, and this kind of goes back to, we'll structure it as, how should founders understand the interactions with investors, even as early days. Just how should they view this, and protection especially. So Godson says, I'm beginning to have some discussions with investors, but they have not incorporated yet. Are there any recommendations for pre-incorporation investor agreements or conversations? And, perhaps, one that allows for conversion after X years and executed based on the business value at that time in the future. Point is this, that maybe the direct question is, has not incorporated yet, and actually having conversations with investors. What are your thoughts on that? And what would you suggest as soon as possible?
So, I mean, I'll take it's a two-part question. The first part is, pre-incorporation conversations with investors, and then the other is, the value of the investment based on a future valuation. Okay. So the first part, if you think that the conversations are serious, don't waste time, incorporate. You should not be in business without an entity, period. With investors or without investors, you should incorporate. You should have an entity. That's, business 101. You must have an entity, or you are putting your entire life at risk. And that's just not worth it, considering how inexpensive it is to set up an entity. So on the first part of the question, I would say incorporate now and get that done. It's going to show your investors that you're serious. No one's going to want to invest if you haven't even created an entity. So incorporate now. and you know, that's the risk that you're taking. How's an investor going to feel about investing, I don't know, 500,000, $1 million or more in your business when you haven't even taken the risk of creating an entity, you know, of spending that money. So I think, you know, the first part of the question is incorporate. End of story. There's it's hard for me to imagine a situation in which incorporation or creating an entity to run your business is not necessary. So the second part, when it comes to an investor gives you, you know, agrees that they want to invest in your company. There are the number of options are almost limitless. You know, everything from a simple safe to, you know, convertible notes and, you know, loans and you name it. So if an investor wants to put money into your business, one of the easy ways is going with a safe. A safe is a standard agreement for future equity, which means the amount that they're going to get is defined on the valuation given to the company at a future priced round, right? That is, you know, the safe agreement is something that Y Combinator came up with, and it has become pretty much a standard. So that's one way to do it, and I think it's pretty standard. It's you know, anyone out there understands what this is. It's not. It's becomes easy to understand, and investors are very comfortable signing safe agreements. So that's the way that I would address funding your business without going through the burden of going through evaluation, because evaluation really, especially at the earlier stages of a business, are pretty much meaningless. Nobody really knows what the value of a very early stage company is until, you know, they've grown, they've matured, they have a track record, they have you know, X amount in sales, you know, their profit margin is X, you know, all of these things are really what give a company valuation. But when an early stage company hasn't even gone through these things, they're pretty much impossible to accurately value.
Yeah. And going off of this question, Aaron has a question here, right? One of the recent questions here. How do we show investors that our entity, in this case an LLC, owns the code of the application they're building? Maybe a different way to say it is, you know, how are they making that entity the legal owner of the code developed by one of the members? So maybe talk about IP assignment or how that works.
That's exactly what it is. It's going to be what's going to show that that belongs to the entity is the agreement that you have with your developers, if it's developed not by the founder, and if it's developed by one of the founders, then an IP assignment agreement where, you know, they're founders, and in their agreement, and that's why all of these things are so important. I've seen cases where you know, there's three co-founders. One of the founders is the guy that's writing all the code, and then they start succeeding, and then he wants to, you know, hold the code hostage for the company, but they didn't do an IP assignment. So he says, well, the code belongs to me. When in fact that was his contribution to the entity. Now there was a big fight ultimately. Now you don't want that to be the case. So the co-founders need to come up with these, you know, agreements, and one of them is an IP assignment. Everything related to the website, you know, the app, this thing, whatever it is that it is assigned from, you know, by the the co-founder or the partner or whatever to the entity. And then the entity owns it from that point on. So that's how you prove it. Here's the agreement that the CTO or the developer signed. And then if you hire another developer or something like that, you make sure that in the agreement, any IP produced is assigned automatically, and that any work that they do is made as work for hire. So those are the things that you really have to do to show that the intellectual property belongs to the entity and not the individual.
Awesome. All right, and everyone, we're kind of getting to the end here. We're closing up. We had a quick question, and I think this is a great way to summarize or at least leave everyone today. Is Roger asked what differentiates ScaleUp from other law firms that also offer their services for equity and others. So maybe summarize, Alberto, with your take on yourself. This is you selling yourself and your firm. And then
Well, thank you for the opportunity. So, well, one of the big things is our experience, right? We've specialized in all things business. We don't do family law, we don't do criminal law. We specialize in all things corporate, and that includes business immigration, that includes corporate law, contracts, uh, venture capital, intellectual property. And that's what we do. So we're specialists in that. Second, how we become investors is we use a safe. We use a standard investment vehicle, right? So when we do participate and we take equity in a company, we use a very simple agreement, and it's a standard agreement like the Y Combinator safe, where we don't even have to go through evaluation. And in the end, the idea is we charge you very little. You get an in-house counsel, because very often what we have found with our clients that come not under our programs, but that just come for us to represent them, is that they'll come and be like, well, we didn't sign an operating agreement. We don't have a founder agreement. We don't have a board of directors agreement. We don't have an IP assignment agreement. We signed this partnership with these people, and then in the end, the agreement gives them all the rights to everything, and now we want them back because the partnership didn't work. When you're part of one of our programs, first of all, we're invested in you, so we are not just incentivized by fees, but we're incentivized by your success. Second, you have someone that you can pick up the phone, reach out to and say, look, we're considering this partnership with this company. They have an army of lawyers. Twitter wants to buy us. What do help us out? Or, we are, can you review our employment contract because we're bringing in 5 additional people? What are we going to do? We're going to look at, make sure that IP assignment is done correctly, all of these things. How do we structure our offering to investors? Well, we'll do that. We'll put you on a cap table. How do we attract investors? Well, we'll put you on the right platforms where, for example, if you're not gonna be seen by investors if your cap table is not in the right place. So we put you on the right places for investors to find you. We actually put you in front of investors that want to invest in companies like yours. So, so that's I think a gigantic difference that we've developed as a result of my time as a startup founder myself, and then as the in-house counsel for other startups, where we've been able to help them raise capital, protect their interests, and ultimately succeed. So
well,
that's what I have to say.
Yeah, and I'll summarize that by saying, as you can hear, they care. He cares. They care about your success, and there's things in place to really make sure that happens. And unfortunately, we're at the end of the hour here, and obviously more questions. So if you all see that link, feel free to get on the Alberto's calendar. You'll have more of a private conversation. You can ask probably more detailed questions, and he'll help you out there. And so with that, Alberto, thank you so much for joining us today.
Thank you, Nick, and thank you everybody for joining. And yes, please connect and we'll have a conversation as to help you figure out all these legal things. So
Great.
thanks, Nick, and thanks everybody for joining.
Welcome. You're welcome. This has been Founders Live Conversations. We're here with Alberto from ScaleUp Legal. You'll see that information in the chat there. We're about ready to close the room. So if you need to grab that link, grab it quickly. We have these every so often throughout the months. Typically, we do about two conversations a month with a lot of our different partners and different topics. So keep watching, keep listening. And hey, we'll see y'all at the next one. Enjoy the rest of your day or evening or morning.